Yes. First of all, we read the quotation. जब दुनिया हमें कहती है हार मान लो. जब दुनिया हमें कहती है कि हार मान लो, उस समय उम्मीद हमें कान में कहती है एक और बार कोशिश कर लो. अगेन, वंस. एक बार और कोशिश कर लो. यस. क्वेश्चन नंबर फर्स्ट. Question number first. To prove the execution of a registered will. To prove the execution of a registered will require at least one attesting witness. It is mentioned in the section 68. Section 68 says that to prove the execution of registered will, to prove the execution of a registered will, section 68 says that at least one attesting witness must be required. So the answer of the question 1 is B. Next, under Indian Evidence Act, a document required by law to be attested can be proved by calling. Under Indian Evidence Act, a document required by law to be attested can be proved by calling at least one of the attesting witness. Section 68 says that. Okay? Answer B is the correct answer of the question. When attesting witnesses are not required to call to prove the document, when the document is not a will. It is also mentioned in the section 68 proviso, says that when the document is not a will and if it is registered, and if that is registered, then no attesting witness are required. So the correct answer of the question is A. A is the correct answer of the question. An attested document not required to be attested may be proved. An attested document, if it means the document is attested. If the document is attested, that document not required to be proved by calling at least one witness. So an attested document not required to be attested may be proved by calling at least one witness. No, because the document is already attested. Calling both the witness, no, the document cannot be proved without calling the attesting witness. Yes, witnesses are not required to attest the document. So the correct answer of the question 4 is D. D option is correct. Under which section of the Indian Evidence Act, the court can itself compare the handwriting of a person. Under which section of the Indian Evidence Act the court can itself compare the handwriting of a person? Section 73. Yes, 73. Court compare the handwriting. So option B is the correct answer of the question. Option B is the correct option of the question. Next, under which provision of law? Under which provision of law can a court direct any person to write any words or figures for comparison of handwriting? Under which provision of law can a court direct any person to write any words or figures for comparison of handwriting? For comparison of handwriting, yes, section 73 of Indian Evidence Act. This is the true answer of the question. Who among the following can compare the disputed writing with the admitted writing of party? Who among the following can compare the disputed writing with the admitted writing of the party? The court, yes. A handwriting expert, yes. By anyone familiar with the handwriting, yes. Any of the above, yes. D is the correct answer. Any of the above. Any of the above can compare the disputed writing with the admitted writing of the party. So the correct answer of the question 7, D. D is the correct answer. Next. In which of the following case did the Supreme Court hold that compelling a person to give his specimen writing will not amount a testimony? Testimonial compulsion for purpose of Article 220 for Article 20 class 3rd of the Constitution of India. Article 20 class 3rd explains about the self-incrimination, protection against self-incrimination. So any person cannot be compelled. Any person cannot be compelled for making signature. So in which case it is decided? See here, in which of the following case did the Supreme Court hold that compelling a person to give his specimen writing will not amount to testimonial compulsion for the purpose of Article 20 class 3rd of Constitution of India? Yes, it is decided in the case Kathu Kalu. Kathu Kalu versus State of Bombay. It is decided that person cannot be compelled a person to give his specimen writing will not amount testimonial compulsion. This is decided by the Supreme Court in the case of State of Bombay versus Kathukalu. A is the correct answer of the question number 8. Question number 8, option A is the correct. Which of the following section defines public documents? What is public document? Section 74. Section 74 says about the public document. Next, a private document which is kept as a public record, though the document is private, but it is kept where? As a public record. If a private document is kept as a public record, that private document shall also be called public document, not private document. Though the document was private document, that document shall be regarded as a public document. Why? Because the private document was kept as a public document. Okay, so such type of private document, if kept in publicly, anyone can read, anyone can study that document who desire. It means that private document also shall be called as a public document. So the correct answer of the question is A. A is the correct answer. Okay, that's all. Thanking you for watching video. Thanking you. That's all. Okay, thank you. That's all.